Okay, welcome everybody. I'm Marie Chen. I'm here as chair of the board. Technically, that makes me AV's boss. Sorry? Oh, it's not. So AV interrupts me when I'm trying to make a joke about her. So I'm chair of the board, and I'm technically AV's boss, but anyone who knows her knows that that's a contradiction in terms. And if you're LAO, I'm just kidding. So thank you for coming out and joining us in such large numbers to celebrate our 25th anniversary. This is the first part of the celebration. There will be a reception afterwards upstairs, and we hope that you can join us there. This anniversary is an immensely significant event for our community. In the last 25 years, the clinic has advocated tirelessly to protect the legal rights of low-income immigrants and refugees from Toronto's Chinese and Southeast Asian communities to ensure that they have access to justice. We estimate that the clinic has helped over 70,000 people since its inception, providing legal advice and representation. The clinic has had an immeasurable impact not just on individuals it has assisted, but also a much broader one through its test case litigation, law reform, and public legal education activities. One of the clinic's major achievements was its instrumental role in the enactment of the Redress for Chinese Hit Tax and Exclusion Act by Parliament through its class action lawsuit against the federal government on behalf of surviving hit taxpayers and families. And all this with 5 staff and limited resources. Truly amazing. And you can help support us by buying raffle tickets, which are available out at the front. They cost $20. And prizes are good. They include 2 return tickets to anywhere in the US except Hawaii, and 2 weekend getaway cottages in Muskoka. The odds of winning are very good, 1 in 60, and it's all for a very good cause. So please buy the tickets when you leave. The theme of this conference is Championing Equality, Progress or Peril. We thought that on our 25th anniversary and on the 30th anniversary of the Charter, that we should take stock of the efforts made to address inequality in Canada. Since the clinic's inception, has anything changed on the equality front? How far have we come, or have we regressed? What have been the challenges? For the Chinese community, are the days of the yellow peril long behind us? Or are we still experiencing anti-Asian prejudice, albeit in a modern-day incarnation? As a legal clinic, we use the law to protect and access rights. But has the law helped in achieving equality for our communities? Has Section 15 of the Charter been a useful and effective tool for equality-seeking groups? Has it lived up to its promise? What was its promise? And looking forward, what does the future hold? To explore these issues and others, we're very pleased to have with us several distinguished guests and experts. Our first is the Honourable and the former Chief Justice of Ontario, Roy McMurtry, who will be chatting with Carol Gore. Justice.
Good afternoon, ladies and gentlemen. My name's Clara Ho. I'm the Vice Chair of the Board of the Metro Toronto Chinese and Southeast Asian Legal Clinic. It's my pleasure this afternoon to introduce Ms. Carol Gore. Ms. Carol Gore has been a journalist for more than 35 years in Ottawa, Washington, and Toronto. She covered the negotiations and the Marathon Federal Provincial Conference that led to the Charter of Rights. She followed the struggles of equality-seeking groups for constitutional protection. Since the Charter became law, she has written about the court breakthroughs, the setbacks, the loss of government support for constitutional challenges, and the dawning recognition that legal guarantees aren't enough. Before joining the Toronto Star, she worked as a reporter and writer for several newspapers, a wire service as a news magazine. For 10 years, she served as the Star's national affairs columnist on Parliament Hill. She was also the Star's editorial editor for 5 years. Now she has returned to her first love, writing. She hopes to use her column to illuminate the impact of government policies on people's lives and give a voice to the marginalized and powerless. We would also like to take this opportunity to congratulate Ms. Gore for being the first recipient of the Urban Alliance on Race Relations Ashok Chandwani Media Award. Please join me in welcoming Ms. Carol Gore.
Thank you very much, Clara, for that warm introduction. Is the microphone picking up my voice properly? Can everybody hear? Excellent. All right. I'm a little bit intimidated to be surrounded by lawyers who undoubtedly know more about the Charter of Rights than I ever will, but I've had a little bit of practice asking questions, and that's all I have to do today. The first part of our program, as you've heard, is to set the context and talk about the birth of the Charter with the Honorable Roy McMurtry, who now serves as counsel to the Advocacy Department at Gowlings. But 30 years ago, when the Charter was enacted as part of the Constitution, he was Ontario's Attorney General. That put him at the center of the legal and political action. Can you begin, Mr. McMurtry, by telling us how the Charter came about? There is a widespread perception that you and your provincial colleagues drafted it and decided right up to the end what to leave in and leave out at the many negotiating sessions that led to the final version. Is that in fact?
Well, it didn't quite happen that way. The first Charter of Rights was passed by the, as you know, Carol, by the Diefenbaker government in 1960. But that was just another act of Parliament, so it had no force and effect, and because any legislation could say, notwithstanding the bill, it was called the Bill of Rights in 1960. Then they had another, and then that continued, but it very rarely was ever applied. And then 1971, they had made another effort to try and this time, to patriate the Constitution with an amending formula and a Charter of Rights. And that almost succeeded, but Premier Bourassa at the last moment withdrew the Quebec's support. And then we had the Quebec referendum, as most of us will recall, in the spring of 1980, and during the campaign, Mr. Trudeau promised a renewed constitution, although I'm not sure if he knew exactly what he meant by that. But and I say that he was acting in good faith, and he waged a strong campaign on behalf of Canada. But after the successful federal victory in the Charter of Rights, Jean Chrétien met myself and Bill Davis in Toronto, and then basically that began a long summer of meetings with ministers and a lot of officials, both with the federal and provincial governments. But the issue, the politicians, except for two very major issues dealing with the amending formula and the Charter of Rights and the notwithstanding clause, really did not, the political process would make it impossible for us to draft a charter. I mean, if we tried to, it would be like the proverbial group who sat down to to design a horse and ended up with a camel. And actually, the details of the charter had a lot to do with the federal Justice Committee, federal parliamentarians, and there were many dozens, if not hundreds, of Canadians who had appeared before them, and they actually strengthened the Victoria Charter, because in the Victoria Charter a lot of it was, well, I'm trying to think of the right word, but for example, it said people would be, should not be subjected to, mostly symbolic was what I'm trying, the word I was looking for. Like people should not be exposed or subjected to unreasonable search and seizure, for example. But I'm sorry, in the Victoria Charter, and this is probably getting too complicated, they said unlawful. And basically, it was just symbolic that people had the protection of the law, which they had without. But the Federal Justice Committee changed the right sections so where a number of them said unlawful search and seizure, unlawful arrest and detention, et cetera, they changed the word unlawful to unreasonable. So that meant a major shift of responsibility to the judges. And so, of course, over the years we've heard a lot about judicial activism and whatnot. But I think it's important to emphasize that the judges did not ask for this authority, but the parliamentarians said, no, it'll be up to the judge to determine in the facts of any one case whether the search or seizure, arrest or detention, and et cetera, was unreasonable. So it's kind of like deciding what is the length of the Lord Chancellor's foot. It gave a great deal of attention to, a great deal of judicial authority. And so Canada really changed from a parliamentary democracy to a constitutional democracy as a result of the entrenchment of the Charter in 1982. Now, 8 of the provinces were very much against, as you recall, the so-called Gang of 8, were against the entrenchment of a charter because they believed they had grown up politically and otherwise on the principle of the supremacy of Parliament. And they did not accept the idea or the principle that judges should be able to declare unconstitutional acts of Parliament or parts of acts of legislation that have been created by elected judges and
appointed judges.
Elected parliamentarians should not be able to have their legislation changed by unelected judges. And so this became a very major controversy, and this is where the issue of the notwithstanding clause that came up in order to reach a compromise where it said, well, notwithstanding a section of the Charter, a Parliament could overrule a judicial decision, but only for 5 years. And the other major item of debate was the amending formula. And it had been and of course, the battle in the Supreme Court of Canada had a lot to do with that, and I argued the case on behalf of the government of Ontario. And it was the provinces who said, well, the federal government can't amend the Constitution without the consent of the provinces. It was assumed that they met every province, and which would have been impossible. But what we finally ended up with was simply an amending formula that said that 7 of the 10 provinces representing 50% of the public, and then again there's a lot of background as to the role of convention in constitutional making and the decision that said that, well, the unilateral initiative on behalf of the federal government was strictly legal constitutionally, but it offended a convention, a constitutional convention, Well, up until that time, constitutional conventions were not recognized as legal instruments. And Chief Justice Laskin, in a very strongly worded dissent, pointed that out. But so there is a lot of interesting history to me, of course, because I was there and getting old now. And cling to some of these memories, but it was several major points that were debated by the political leaders rather than the nitty-gritty of the drafting.
So many authors and a very long genesis.
That's right.
That sets the
I'm
stage.
sorry if I went into too much detail, but
No, that's fine.
But these issues can get a little complicated.
One of the most cherished provisions of the Charter is Section 15, which sets out the equality rights to which everybody in Canada is entitled. How did you and your colleagues decide which to enshrine in the Constitution and which not to include?
Well, again, most of the drafting was done by the parliamentary committee, and because the politicians, political leaders did not get into that nitty-gritty, or it would have taken years. Now, I think it was just sort of assumed what would be there, perhaps from the 1971 charter, but I think that the principal gap was the failure to include a prohibition against discrimination on the basis of sexual orientation. And that was presented to the parliamentary committee, and it was not included. But in about 1970, maybe it was about 1995, the Supreme Court of Canada decided to give a very broad interpretation to the equality section, and read in sexual orientation as an analogous subject for protection. And so, much to the annoyance of Ralph Klein in Alberta, they amended unilaterally. The court amended the Alberta Human Rights Code to say that includes sexual orientation as a ground of prohibition.
Was it?
We did the same thing in our same-sex marriage case of Halpern. That's the Ontario Court of Appeal. When I was Chief Justice, we wrote the decision. I was the president of that court that created the legality of same-sex marriage. And basically, we kind of amended the. Well, we didn't amend the legislation. What we really amended was the common law, but that's another subject for a more boring discussion.
But was it the thinking of the politicians at the time that the Charter would be a living document that would evolve as society thought differently about equality rights?
Absolutely. Absolutely, and I think the next Chief Justice, Brian Dixon, talked about the growing tree doctrine, and this is so much different than the Justices Scalia and company on the Supreme Court of the United States, who talk. They have this originalist approach and say, well, no, we're going to, and we've got to decide what the drafters of the Constitution meant. And they rejected the growing tree doctrine in our own Supreme Court, which makes, of course, a whole lot more sense.
Do you recall any discussion of racial equality at the time?
Well, it was assumed that racial equality, that the Section 15 prohibit discrimination on the basis of race. I mean, that was right in the original draft. That did not have to be read in by any of the courts later.
Okay. In the last 7 or 8 years, there's been a chorus of complaints about judicial activism, and they're usually directed at charter judgments. Did you and your colleagues foresee this, and do you believe the courts have overstepped their role defining rather than interpreting law?
Well, as having served as the Chief Justice for 16 years, I'd be reluctant to be critical of the judges, nor should I believe that they be criticized. I want to emphasize the point that I made earlier, that the elected parliamentarians, they handed over this responsibility to the judges. We did not, no judge ever suggested it or requested it. But we realized, speaking as a politician of the day, that we were embarking on uncharted waters, and we could not predict with any certainty as to how the courts would react to this important new responsibility. But having practiced in the courts for many years before I entered politics, I had a fundamental respect for the courts with respect to behaving responsibly. And there'll always be criticism of judicial activism, but I don't think it's justified. Some judges make mistakes, and that's it's always been that way. But I think we've created a very good balance between the elected legislatures and the courts. And I think there is a degree of mutual respect, and certainly judges don't want to be thought to be high-handed in interpreting the charter. But it also should be emphasized, and I know we're running out of time, but it should be emphasized that the Charter of Rights is for the minority, not for the majority. The Charter of Rights is fundamentally a document to protect minorities, and the majority of Parliament are there to protect the majorities. So that's the fundamental difference.
Thank you very much, and I'm afraid we have to wrap this
I
segment of
understand
the
that.
program up.
Nice to see you as always, Carol.
Yeah.
Thank you.
Thank you, and we have a small token of appreciation.
Well, thank you very much. Before sitting down, I'd like to congratulate Abby and her colleagues on this very special 25th anniversary. A job well done, Abby. Congratulations and all the best for the future.
So now we have the panel to discuss the current state of inequality, and I'd like to invite the panel up front.
Here, shall I move in here?
The microphone's ready for me.
Yeah, there's some light. Right here.
Got it. Very good. Very good.
So we're very pleased to have a panel made up of distinguished experts to discuss the issue of the current state of inequality in Canada. On my left, I have David Lepofsky. David is a well-known constitutional law expert and author. For over 30 years, David has been a tireless advocate for laws to protect the rights of persons with disabilities in Canada. In 1980, he was involved in a successful effort to have the then proposed charter amended to guarantee equality rights to persons with disabilities. In the early 80s, he was involved in efforts that successfully advocated for inclusion or protection against discrimination based on disability in the Ontario Human Rights Code. David led the Ontarians with Disabilities Act Committee, which successfully campaigned for 10 years to win passage of the Ontarians with Disabilities Act and the Accessibility for Ontarians with Disabilities Act. For the last 3 years, he has been chair of the Accessibility for Ontarians with Disabilities Act Alliance, which in 2010 succeeded in getting Ontario election legislation amended to address accessibility barriers impeding voters with disabilities. Many of us know that David fought 2 human rights cases against the TTC, which he won in 2005 and 2007. And as a result, the TTC must now announce all subway, bus, and streetcar stops. Next to David is Grace Edward Galabuzzi. Grace Edward is an associate professor in the Politics and Public Administration Department at Ryerson University. He's also a research associate at the Centre for Social Justice in Toronto. He's the author of the book, Canada's Economic Apartheid, The Social Exclusion of Racialized Groups in the New Century. He is the co-editor of Race and Racialization, Essential Readings, and Colonialism and Racism in Canada. His research interests include experiences of racialized groups and immigrants in the Canadian labour market, the racialization of poverty, precarious employment, and the impact of global restructuring on local communities. He's an active member of the Social Justice Committee in Toronto and has been involved in a variety of social justice campaigns. And next we have May Lui. May is the interim executive director of the Chinese Canadian National Council Toronto chapter. She was a board member of the CCNC Toronto from 2001 and 2005. May has a master's degree in adult education and has been an anti-racist and anti-oppression activist, trainer, and consultant since 1996. And next we have Avi Go. And Avi Go has been, for many, many years, the clinic director of the Metro Toronto Chinese and Southeast Asian Legal Clinic. Since 2001, she served as bencher for 7 years. And since 2005, she has been a part-time adjudicator of the Health Professions Appeal and Review Board and was cross-appointed to the Health Services Appeal and Review Board in April 2011. Avi has published articles in law journals, law books, community, and mainstream newspapers on legal and policy issues affecting immigrants and racialized communities. Thank you all. So we have David first.
Good afternoon, everyone. I begin by thanking the clinic for honoring me with the opportunity to speak to you, congratulating the clinic on this tremendous anniversary, and embarrassing Avi. I've had the privilege of working with Avi in advocacy on human rights reform issues together, and it's been a real honor and a privilege. You will find no more effective, more principled, no more respected, and no more liked advocate than Avi. And it's been a delight to work with her and continues to be. The charter was passed 30 years ago with a whole bunch of rights in it after a big long debate, and during that big long debate only one right was added that had been left out of the original draft, and that was equality for people with disabilities. There was a section 15 in the original draft of the charter. It included various grounds. It did not include disability, and it was worded in a way that would preclude disability claims. It was the advocacy efforts of many people with disabilities before Twitter, Facebook, computers, even fax machines, that persuaded the governments led by the federal government to amend the charter. During the patriation debates, the only substantive right added was the disability amendment. I had the privilege, while in this room supposedly hearing Bard Mission lectures, to prepare and present as one of the presenters before the Joint Special Committee in Ottawa that was holding hearings on the charter. What did we win? Well, lawyers usually talk about cases, and yeah, we've won some very important cases. 97, Supreme Court of Canada decides the Eldridge case, says deaf people, when they go to the hospital, should be able to communicate with their doctors. That should be a tough one. But it also said that when governments make and apply programs and policies, they've got to take into account the needs of people with disabilities. That shouldn't be a tough one, but it still is. A year or two ago, federal court decided that when the government posts information on a website for the public to use, people like me who are blind and use alternative adaptive technology should be able to access that information on the web by ensuring it's presented on the internet in a way that is accessible to us. That should be a no-brainer, but the federal government fought it up 2 levels of courts, lost all the way. We've also had cases that we won at lower courts and then lost on appeal. Our Court of Appeal wisely decided that blind kids have a presumptive, kids with disabilities, all disabilities, have a presumptive right to go to school with their peers of kids without disabilities. If the government wants to segregate them, they got a burden to justify it under Charter Section 1. Supreme Court of Canada reversed that one in about 12 hours. The case is called Eaton. It's bad. But I don't want to talk to you about cases. I want to talk to you about what else the Charter has done. The Charter made an entire series of generations of people with disabilities aware of new rights and also aware that it's impractical many of the times to fight them, fight the barriers we face through legal action one at a time, whether it's under the Charter or the Human Rights Code. It takes too long. It's too fatiguing. We often don't get access to lawyers. Even when we used to have a public enforcement agency to back us in Ontario, the Human Rights Commission under the Human Rights Code, that was principally taken away from us in 2006 when the Ontario government wrongly privatized human rights enforcement. So while we need resort to case-by-case litigation, for most people with disabilities who are unemployed or underemployed, who are overrepresented among those who don't work, overrepresented among those who don't work, and overrepresented among the poor, underrepresented among those who could afford lawyers, for them, they needed something else. That led to a movement which was inspired by the Charter and the Human Rights Code back in 1994, and I've had the privilege of serving in a volunteer leadership capacity. It was a movement to get a new law passed, not to change the rights that the Charter and the Human Rights Code guarantee us, but to make sure people actually start honoring them. What we wanted was a new law that would ensure that we would get access to the goods, services, jobs, and facilities, the opportunities that people without disabilities take for granted, without having to sue to overcome those barriers one at a time. If you've heard me speak before, you know what I'm about to do. Pretend you don't. Let's see if this touches you and affects your life. I want to see if you are affected by this issue. I'm going to embarrass you publicly. I would like you to raise your hand, please, if you have no disability now and you are positive you will never get one. Raise your hand. I look around and I don't see any hands. We are the most peculiar minority of all, for we are the minority of everyone. Everyone either has a disability now or will get one if they live long enough, or has someone near and dear to them who has a disability. That's what drove us to call for a new law that would remove the barriers we face and prevent new ones from happening again. We got a weak law in 2001 called the Ontarians with Disabilities Act from the Mike Harris government. We kept fighting till 2005 and won a stronger law, the Accessibility for Ontarians with Disabilities Act 2005. Now, if you want, moment, pause, shameless plug. If you want to learn more about this, Clara's going to pass around 3 things. A pad. On that pad, if you want to get our email updates, learn about our campaign for accessibility, find out what we're up to, print legibly your email address. Second, if you want to know more about us, a fact sheet's going to be given to you. It'll also tell you how to follow us on Twitter at AODA Alliance. Or if you're watching this on video and you want to know how to contact us to get our email updates, just write aodafeedback@gmail.com. And a third page, which I'm going to get to in a moment, but which will be passed around. What did we win in the Disabilities Act? Well, we won a good law. It does something that we believe no one else has gotten in the campaign for equality before. It sets a deadline. It says that by the year 2025, people with disabilities in Ontario, we number over 1.7 million, and we include everybody ultimately, we're entitled to have a fully accessible society. And it requires the government to develop, enact, and enforce accessibility standards that will get us there. So how are we doing? Well, according to an independent review undertaken by the government, by an individual named Charles Beer, whom the government appointed, who reported in early 2010, the government needs to revitalize its implementation of this legislation, breathe new life into it, stop dealing with it as business as usual, show new leadership if we are to achieve full accessibility by 2025. And we agree. My coalition's been actively involved in trying to come up with proposals for how to strengthen this legislation so that it has as good an impact as it can. Now, it's had some real significant impact, and we're proud of that. But there's a lot more that needs to be done and can be done even in a weak economy. Let me just conclude by giving you one example. And we trace this example all the way back to the days that Chief Justice McMurtry was talking about, the heady days of fighting for the charter, and it leads all the way up to events of just 2 hours ago. Rights don't mean anything unless they're effectively enforced. And we have learned from decades of experience with the charter, that the cost of enforcement and the burdens of case-by-case enforcement are often just things that people with disabilities can't bear. So when we approached the political parties, we're nonpartisan, and asked for a Strong Disabilities Act, one thing we wanted was to ensure that it was effectively enforced. A resolution was passed unanimously 14 years ago at the end of this month, October 29, 98, led by the Liberals in Ontario and supported by Dalton McGuinty, then in opposition, promising, among other things, effective enforcement. The law that was passed in 2005 has good enforcement tools, but we don't think they're being adequately deployed. At the very least, and as a very first step, we need a phone number that we can call in Ontario to report barriers and ask for action. There is none. So 2 hours ago, this is that last piece of paper you got, we unveiled our latest strategy, and with this I will close. Our strategy is to ask the government to simply set up that phone number so that we could get some effective enforcement. Because nobody else will give it to us, our solution is dial Dalton. You'll see a page which invites you, starting on the 14th anniversary of that pledge, to call the guy who made it and ask, who do we call? Tell them about barriers you know about. This has already been retweeted to 80,000 people in the past 2 hours. And using the same strategy that helped us win the amendment to the Charter without that technology, using the same strategy that helped us win the Disabilities Act, our aim is to win effective enforcement and to win it now. Thank you very much.
Thank you, David. I forgot to mention earlier, we'll have a chance to ask questions after all the panel members have finished speaking. So next we have Grace Edward Galabuzzi.
Thank you very much, Marie. It's always tough going after David because he's so dynamic and it's almost a letdown to have to speak after him. But I also should concede to something else, which is that in a room full of lawyers, my competency to deal with the Charter of Rights is severely diminished. If it's my class, it's a different matter altogether. So I will stick to some of the social science around issues of economic inequality that I was asked to speak to. So thank you very much, and I also want to both pay tribute to the Metro Toronto Chinese Southeast Asian Legal Clinic for the work that they've done over the 25 years that they've been in existence, and we hope both that they will be here for many more years and that Evie will not become a judge. We've been fighting a rearguard battle with the judiciary around that issue. We still need her here. I also want to pay a quick tribute to Charles Roach, who's very much like David Lepofsky in terms of the commitment to struggles of disadvantaged and oppressed peoples. Charles Roach passed away a couple of weeks ago, and he will be dearly missed in that he represented what was best among us in that struggle. But I want to move on to paying another tribute. And the tribute really is in relation to the topic I want to talk about today. And that tribute is to Occupy Toronto. Occupy Toronto, some of you who have been paying attention over the last years, started this very day a year ago. And I think that in some ways they captured the imagination of the very people we have been trying to get across to the need to focus on the issue of economic inequality, income inequality, and social inequality in this city. And they framed it fairly effectively by talking about the 1% versus the 99%. And I think that that, in many ways, has changed the conversation in this city and in the country, and I would say probably around the world, with regard to the issues of the disproportionate distribution of income, and particularly the gains of productivity and wealth creation in this society. So in the few moments I have, I want to talk about why we are particularly concerned about inequality, particularly concerned about income inequality. I want to suggest that we're concerned about inequality because it determines opportunity, access to opportunity, not just for this generation, but across generations. Inequality affects both the upward mobility of people in our society, but perhaps even more importantly, it affects the capacity of the community or the society to optimize its own human resources and thus its economy and social development of that society. In particular, the groups that are disadvantaged by this process, whether it's a 99% or in the case of the work that I do, the racialized populations, what this means is that we are likely to have intergenerational impacts and effects that leave our society the poorer. In fact, the problem with regard to the issues of low wages and frequent unemployment and underemployment is that it triggers disruption of the virtuous cycle, and it sets in a vicious cycle that captures both various generations, across generations, but also people in our society. We know now, we do have enough research to suggest that our society has become progressively unequal over the last 30 years that the Charter of Rights and Freedom has been in place. I'm not suggesting that the Charter of Rights is responsible. I'm not suggesting a causal connection between the Charter of Rights and this progressive inequality. I would suggest that progressive inequality has had to do with neoliberalism, which is another conversation for another time. It just so happens that these two processes have been in place at the same time. One of the perhaps most dramatic expressions of this inequality is contained in a report that was released recently. This is in the United States. It talks about in the year 2009-2010, 93% of the income gains in the economy went to the top 1%. 93% went to the top 1%. And we might say that that has nothing to do with us. The Canadian patterns are different. But a report by Suez and Veal, which was released last year, shows that in the Canadian context, similar patterns do obtain. The top 5%, the top 5% in the Canadian context over that period of time took about 29% of all the income of all the income gains. No. The top 5% took about 29% of the wealth by the year 2000. So I think that it's important for us to try and confront the issue of income inequality in the Canadian context, because the continuing concentration of wealth in the hands of fewer and fewer people means that we're disrupting the virtuous cycle of economic development. In fact, we're getting to the point where, as Marx told us, I don't know whether people can still quote Marx in this moment, Marx talked about capitalism containing the seeds of its own destruction. And in many ways, this is where we are headed, because that concentration of wealth in fewer and fewer hands cuts off the pathways. It takes away the ladder from the broader population to engage in broader economic expansion. Inclusive economic systems are more dynamic. They tend to increase and expand the opportunities for many in the society and lead to the possibility of expanded income generation and redistribution. The alternative to that, in many ways, is the causing in the restriction of opportunity to fewer and fewer people, but in most cases, the privileged people. So let me just spend a bit of time talking about what I see to be the situation within the Canadian context. First of all, Canada has expanded over the last 30 years. Over that period of time that we're talking about, Canada has expanded in terms of economic generation, economic development. Canada is now the 9th largest economy in the world. The concern is not that Canada has not expanded, but that during that period of time of expansion, what we have had is a growing income gap between the rich and poor. It is at its highest now than it's ever been over the last 30 years. It means that fewer and fewer people are able to take more and more income home and to concentrate more and more wealth. The bottom half particularly shut out of the income gains that we have seen, and increasingly people are working, but they are poor. We have shifted from people being out of the labor market, the majority of people who are poor being out of the labor market, to increasingly people in the labor market, poor people being in the labor market. So we have moved away from the position where I think Mike Harris suggested at some point that the problem with poverty is that we need to get poor people off of their backsides and into the labor market. They're in the labor market and they're still poor. So the major trends over that period of time is that, as Works has suggested, a growing income inequality between the sort of managerial professional class and the working class. And, oh, wow. And that growing income inequality is also reflected in by race and by gender. And I'm going to spend a bit of time just talking about that. So I want to talk about that connection between the growing income inequality and the racialization of that income inequality. A couple of things that I think are useful here. One is that what social scientists tend to use when they're talking about issues of income inequality is they use the Gini coefficient. A number of really interesting data that help in this regard. If you look at the shift in Gini coefficient from 1990 to 2006 for Canada, it is from 0.28 to 0.32. We're becoming more unequal. But the Toronto CMA is dramatically more unequal, 0.29 to 0.45. I want to suggest that part of the reason that explains that inequality is because of the extent to which the inequality within Toronto is defined by class, but rather by race, along, of course, with class. And part of that has to do with the nature of the labor market and the extent to which that labor market has become increasingly more unequal. Access to opportunity has become increasingly and persistently more unequal. And there's a number of explanations as to why that is the case. The neoliberal deregulation and re-regulation has led to this to a certain point. The persistence of or the growth of precarious employment, temporary part-time work, low wage and no benefit types of work. And that Aboriginal racialized people tend to be disproportionately represented in the sectors where precarious employment is a major feature. And so that is reflected in their levels of unemployment and underemployment and income. So I'll very quickly run through that. I probably don't have a lot of time, but I'll run through that. So my concern here is the extent to which that leads to differential access to labor markets, income inequality, income insecurity, the racialization of property in particular, but other dimensions of impact, whether that is in health disparities or neighborhood segregation, and I think the important dialectical outcome, which is the communities have been organizing and mobilizing to fight back, and certainly that is the case with regard to what's been happening with Metro Toronto Chinese Legal Clinic. Okay, so just a few data, and then I'll step down. So one of the things that's happening in Canada is that Aboriginal populations are growing much faster than the rest of the population, and this is reflected in the growth from 1996 to 2006 from 290,000 to 538,000. But in spite of the fact that they're growing that significantly, their experience in the labor market does not reflect the strength that we would suggest comes out of that growth. In fact, what they seem to be experiencing is a regression in the labor market. Now, in 1996, the gap between racialized Aboriginal and non-Aboriginal populations was about 44%. It went down to about 27% in 2001, but it's gone back up to about 30%. That gap is also reflected in the sort of urban and rural populations. If you will notice that the urban population of Aboriginal residents has actually a higher level of income gap than the rural population. There's a lot of unpacking that needs to be done there, but I can't get into that. Okay, so let me just end by talking a bit about a study that we did recently with Sheila Block that looks at a variety of indicators of socioeconomic status, employment by race and gender, employment rates by racialized group, and others. So quickly, the unemployment rates, the differentials in terms of unemployment rates for racialized groups, both women and men, is significant. Amongst men, it is 7.8% for racialized men, and amongst women, it's 9.3%. That is the level of unemployment. And it is lower for non-racialized men and women, 6.3% and 6.1%. That sort of reflects in when you disaggregate that, and one of the things that we're trying to do increasingly these days is to do a disaggregation of this data so that we have a sense as to what's happening to particular communities as opposed to simply dealing with that broad category. So if you just disaggregate, what you see is that that experience is right common across the board except for the Filipinos and Japanese, and I know that that's coming. So employment, let me just do employment income, which is for amongst men, racialized men are at 35,000 and non-racialized men are at 45,000. Women, so these processes are highly gendered. Also, women are 25,000 and non-racialized women at 28,000. The difference between racialized women and non-racialized men is significant. It's close to about 50%. And yet we are asking these populations to coexist in the same economy, in the same market, to essentially fight for the same housing, same access in the market. And I think that is significant. So that essentially leads to the concern around low income, which is that these groups tend to have a significantly higher level of low income. On the national level, it's 19.8% versus about 6% for 6.8% for the non-racialized groups. But clearly what is consistent is right across the board, all these groups tend to experience higher levels of low income. In Toronto, it's actually even higher. It's about 28% of those groups. And at some extent, that is part of why we have been talking about this experience of low income as racialized. So when we talk about racialized poverty, what we're essentially talking about is the proportions of people in racialized communities that are living in poverty, as well as the proportion of those who are poor who are from racialized groups. And in both cases, what we're finding is that the experience of racialized poverty is persistent. I'm going to leave it there because I'm over my time. And if people have any questions, I'll be around somewhere here. Thanks a lot.
Next, we have May Louis.
Hi, is this okay? Is this good? Okay. I'd like to thank you for inviting me to speak today, and congratulations to the Metro Toronto Chinese and Southeast Asian Legal Clinic on 25 years. That's quite amazing accomplishment. I've been asked to bring a community, frontline, grassroots perspective to the panel, and I'll be talking about 3 topics. The first is, has the Charter eliminated overtly racist laws and discrimination? And also a bit about what CCNC Toronto is doing. The second, does the Charter make it easier for racialized groups to make complaints about discrimination? And finally, what can legal clinics and other supporters of social justice do to help advance the rights of racialized communities? So in terms of the first section, Unfortunately, no, the Charter has not done away with overtly racist laws such as the Chinese Head Tax and Exclusion Act of a number of decades ago. I'm just going to mention 3 current examples. Bill C-43, the Faster Removal of Foreign Criminals Act, which includes a measure that would allow the immigration minister huge discretionary powers to decide who can enter the country and the power to deny temporary resident status to whoever the minister decides. The second would be the Refugee Health Care Cuts Bill, which denies health care to people from not yet defined safe countries and failed refugee claimants waiting for appeals or deportation. This was recently amended after community protests to include impoverished refugees. However, it remains highly discriminatory and problematic. And there was actually something in the paper yesterday from Saskatoon about an MP there, Kelly Block, who sent around a flyer to her constituents that says, "Ending unfair benefits for refugee claimants. New arrivals to Canada have received dental and vision care paid for by your tax dollars. They've had free prescriptions. Not anymore." So anyone wants this reference, you can ask me about that after. And I just wanted to briefly mention a bit connected to Grace Edwards' comments about wages. Current laws on minimum wage, with the lower rate of 15% less for foreign temporary workers. Ontario's minimum wage is $10.25 an hour. 15% less than that is $8.70 an hour. Both those wages are below the low income cutoff, just so people know, for a single adult in a large city. In terms of the question about the existence of the Charter eliminating discrimination against Chinese Canadians and other racialized communities, no, unfortunately, the Charter has not done that either. Well, of course, having a Charter of Rights and Freedoms is preferable to not having one. Words alone will not eliminate racism and discrimination. This is similar to what David was saying earlier. Only actions will do that. We need laws with consequences for those who violate the Charter, laws which are enforced. Such actions will begin to chip away at the system of discrimination and racism that pervades Canada. Just a few examples of state-sponsored discrimination, violence against the police, against Black African Caribbean Canadians. There's a report by the African Canadian Legal Clinic, the Police Use of Force document. Aboriginal Canadians and their experience with violence by the police. One example of many is the Ipperwash Inquiry launched in 2003. Lack of police action in support of the missing and murdered Aboriginal women in British Columbia, and the Native Women's Association of Canada, and the recent inquiry into the RCMP misconduct would be further examples. And state-level discrimination against Muslim Canadians, a report put out by the Canadian Council for Refugees entitled "Feeling the Chill: Discrimination Against Arabs and Muslims in Canada." And in terms of issues that CCNC Toronto is involved with, we have an upcoming conference called Happy Two Asians, celebrating activism against activism against racism in media. I have postcards, so please come get some, and there's some on the desk up front. It's on Saturday, November 10th at Ryerson University. This marks the 2nd anniversary of the racist article in Maclean's magazine entitled "Too Asian," in quotes with a question mark. And this article very much mirrors similar themes faced by the Chinese Canadian community 30 years ago when W5 aired a program called Campus Giveaway, which was the impetus for the formation of CCNC as a local and then national organization. We're also involved with the Chinese Workers' Rights and Safety Project, which is focusing on Mandarin speakers living in Toronto and the various workplace discrimination and issues that they face, low wages, health and safety issues, unpaid wages, any other issues that we're doing. So it's a combination research and outreach program. And finally, we are constantly denouncing racism in the media. Two of the most recent examples are the $100 bill controversy and a recent racist ongoing program on 102.1 FM The Edge, which there's a racist character who is either Chinese or is pretending to be Chinese, speaking as someone who speaks English as a second language, who is made fun of by the host. So we actually have a complaint that's in process to the CRTC, and we'll keep you posted about that. The second point is about having our rights entrenched in the Constitution made it easier or more difficult for racialized groups to voice concerns of discrimination in the broader society. So first of all, on the ground and on the front lines, many newcomers to Canada are not aware of their rights under the Charter. Secondly, because of narrower definitions of citizenship, more and more newcomers are not actually covered by the Charter. And thirdly, even for legal immigrants, as well as Canadian citizens from racialized communities who are first or 1.5 or second generation or more, experience mild to severe racism on a day-to-day basis. Lastly, even when people are aware of the rights to which they are entitled, because of power imbalances in our society, which has been talked a bit about already today, complaints are difficult to get heard, to see through, and even more difficult to win. The violation of people's charter rights, employment rights, and other civic rights happens all the time. A few examples from our case logs involving Chinese Canadians in Toronto. A man contacted us who had been harassed by his employer, who created a poison work environment for him. He had to resign from his position under great emotional duress. He's not able to work, and because of a delay in his bringing his complaints to his union, the union is unable to help him. A woman working for a hairdresser who told us that her boss takes a percentage of her wages on top of the fee he charges for her chair in his shop. She's treated like an independent contractor, and so she has no EI or CPP benefits. A woman who's working in an office is being racially harassed by coworkers, all of whom are white women. When she politely asks them to stop, she's mocked and told to get a sense of humor. She knows her colleagues are feminists and can't understand why they think racism is okay. The one other racialized woman in her workplace is afraid to make a complaint to management with her. And finally, what, if anything, can legal clinics and other partners in the social justice sector do to help advance the rights of racialized communities? We need more public awareness campaigns in many languages and in locations that racialized communities are going to see them. We need more partnerships between organizations with resources and grassroots community groups to ensure that the excellent community work that is done on the ground is well funded and not going from project to project. We need a united voice to speak out to all levels of government to ensure that the most vulnerable of our population do not fall through the cracks of a system that is being designed more and more to isolate them. And we need leaders in position of influence and decision-making power to speak for the marginal populations that aren't heard. Thank you.
Thank you, May. Now we have AV.
Can you hear me at the back? Thank you very much, and thanks, Mr. Justice McMurtry, for your kind words. And I want to specifically thank David. Because of him, every time I take this, more the bus than the subway, because there are only so many subway stops. After 20 years, we still haven't had any new subway. But every time I take the bus, I thank David. Because of him, I know exactly where I'm going to get off. So, as you can tell by now that the theme is, while we're celebrating 30 years of the Charter, there are still a lot of struggles in the community. There's still a lot of issues, particularly issues around racism, discrimination, facing different marginalized groups. So as we celebrate, we also need to take stock, and there are many people of influence in this room. We have Human Rights Tribunal members, lawyers from various clinics, and I do hope that the comments that are being offered today will be taken back as you deliver your job on a day-to-day basis while you're making decisions that affect people in the low-income sector from the various marginalized communities. My job today is to talk about some of the issues that are faced by our clients at the clinics, and because of the time limit that I imposed on myself, I'm just going to focus on immigration area, and I'm also going to talk a little bit about the barriers in accessing legal services in order to advance the charter litigation. And because our clinic serves low-income people from the Chinese and Southeast Asian community, so the issues that I talk about will have a more disproportionate impact on those communities. But I guess I will start by saying that despite Canada's image as a multicultural and some would argue a post-racial society, racism, particularly systemic racism, is still very much alive in Canada. And although we don't have overtly racist laws, such as the Chinese Head Tax and Exclusion Act, but as May mentioned, the fact is there are various areas of laws that still affect our community in a negative way. And since the Conservative government came into power in 2005, there have been many changes in the immigration law area. We have a very, very hardworking immigration minister, and he's probably the most hardworking ministers on Parliament Hill. And so under his watch, the immigration system has undergone fundamental change from a system that focuses on permanent residents to one that emphasizes guest workers, and from a system that embraces family reunification to one that is catered towards privileged young professional English-speaking people, preferably from Ireland. So to start, the number of temporary foreign workers in Canada has more than tripled in the past decade. Most of the temporary foreign workers are racialized, and they are employed in low-paying work with little protection. And in 2003, the total number of guest workers in Canada was just over 110,000. By December 2010, that figure is increased to 282,000, more than the total number of permanent residents who were admitted into Canada in that year. At the same time, greater emphasis and greater requirements have been put on family class sponsorships and even greater restrictions on who gets in as family class members. So for instance, increasingly restrictive financial eligibility requirements have barred many low-income Canadians from sponsoring their families overseas. And as we learned from Grace Edward, racialized communities, recent immigrants are overrepresented among the poor. So the financial requirement has a disproportionate impact on these communities as well. And of course, because immigrants from Asia in particular and many parts of the global south are more likely to apply through the family class stream, and they are also more likely to adopt an extended family structure. So the changes to family class immigration have the added desired or maybe not desired effect of restricting immigrants from these countries. And late last year, the Canadian government actually put a moratorium on the processing of all parents and grandparents' applications and replaced it with so-called super visa system for parents and grandparents to come to Canada to visit. However, those who apply must pay for costly private health insurance, and they must still meet the low-income cutoff requirement. So the changes actually affect many immigrants from Asia who make up a large proportion of parents and grandparents applicants. Changes have also been made to the spousal sponsorship program, resulting in spouses in genuine relationship being denied permanent residence. And before the changes were made, the minister actually visited India and in China with the purpose of quote-unquote, cracking down on fraudulent marriages. So there's no misunderstanding as to who are being targeted by these changes. And if the minister has his way, he will introduce a new conditional visa on all sponsored spouse so that they have to stay with their sponsor for 2 years or lose their permanent resident status. And if passed, the change will effectively trap sponsored immigrant women in abusive relationships. And I remember the first test case I actually did at the clinic was about sponsored fiancé, because we used to have a law where women had to marry their fiancé within 90 days after they come to Canada, or they will be deported. And of course, many women that we saw at the clinic, they were afraid of being deported, but at the same time, they don't want to stay in a relationship that was very abusive. And so we actually launched a charter challenge, and sometime after that, the law was changed so that there was no longer the requirement, and now it seems like we're going back 20 years by introducing this new law. The minister has also started to implement Bill C-31, as mentioned, the Protecting Canada's Immigration Act, to overhaul the refugee determination system. The new system creates different categories of refugees from different countries. They bar certain groups of claimants from appealing decisions, negative decisions. It hastens the processing time and gives the minister more power to detain claimants, including minors over the age of 16. It also imposes a 1-year ban on failed refugee claimants to make humanitarian and compassionate application, as well as the pre-removal risk assessment application. This new law is definitely clearly discriminatory, as it creates a two-tier refugee determination system. And the new unrealistic timelines will be hard for all refugees, but particularly for vulnerable refugees such as women fleeing violence, as well as LGBTQ refugee claimants. It is harder for them to make a claim within that strict timeline. And of course, to make the matter worse, Legal Aid Ontario has recently announced drastic cuts to the certificates for refugee cases, effectively denying many refugees legal representation. Another change that has in the past, as mentioned, is the new requirement for citizenship applicants to provide upfront evidence for their language ability, which also pose an impediment, particularly for women who have less access to education in many of the global south. And finally, the vaster removal of Foreign Criminals Act. I love this government. They come up with all these like really fun, titles, and that will facilitate the deportation of permanent residents who have been convicted of just one crime and sentenced to 6 months in jail. Of course, these are all issues that can be challenged under the Charter. Many of them, I'm sure we can argue that they are violating Section 15, the Equality Rights, Section 7, the right to life, liberty, security. And there are many groups that are doing various or considering challenges to the new refugee law. Our clinic is still working on various challenges, including challenge to the LICO requirement in sponsorship. And I'm sure the new immigration criminality provision will be challenged once it becomes law. But launching a charter challenge is never easy, and it's even more difficult if we're talking about some of the most vulnerable population in our society. Because of their vulnerability, many racialized immigrant populations are very reluctant to take the government to court, and for good reasons. They fear retaliation if they do so. And many don't have the money, as mentioned, to hire lawyers, let alone taking on a constitutional challenge. The defunding of the court challenges program and the continuing underfunding of legal aid makes it impossible for many advocacy groups to undertake test case litigation. And for our community, the underrepresentation of racialized communities in the legal profession means there are fewer lawyers to work on these cases. And at the same time, many of our community members find it difficult to access the non-racialized sort of like legal services because of various barriers to access to services. While the specialty clinics that are set up to serve them don't have the adequate resources to assist them all. And I would add the lack of diversity of the bench. Judges don't always understand or even want to acknowledge the existence of race and racism. So all of these reasons explain why charter challenge initiated by racialized and immigrant communities are so few and far between. And in the context of immigration and citizenship law, charter challenges have actually not been helpful to advance the rights of immigrants. Since the Andrew case, which was the first equality right case that set out citizenship as an analogous ground, the rights for permanent residents has been gone downhill since then. The Supreme Court and the federal court in particular have really not protected immigrants from discriminatory laws. We are hoping, for instance, with the criminality provision being tightening up even further by Minister of Kenney, potentially this is an opportunity for us to overturn some of the most ridiculous decisions like the Chiarelli case of the Supreme Court. But given all these problems, why do we still use the charter litigation to push for social change? Well, because it is a tool, and sometimes it is the only tool when the government does not respond to us, when we don't have the political clout. And if you read some of the polls, when it comes to refugees, immigrants, as mentioned, the public sentiment is against them. So the court sometimes is our only resort, if not the last resort. So at the same time, I think it's also important because just by suing the government, we are sending an important message. We are exercising our democratic rights. And we're also sending a message to our community that our rights have to be respected, but we need to empower ourselves to stand up for our own rights because nobody else will. So that's my point.
Thank you, A.B. We have a few minutes for some questions. If you have any questions, please come up to the mics in the middle of the aisles, and please identify yourself when you ask a question.
No questions? I completely agree with everything you said.
No?
Good evening. Am I on?
Yes. Yeah, it's on.
Can you hear me? Okay, good evening. It is most definitely what I consider to be a privilege to be in your midst. The question is directed to David. You spoke concerning about disability and whatnot, and the case that was brought to court, and it was basically granted favor, and it was somewhat repealed thereafter. You did not really mention what exactly was that matter, that the issue of the matter. You did not, if you did, it kind of slipped me. Oh, my name is Richard Mitchell, Reverend Mitchell, and I just basically wanted to get more gist of it, and why the judge or the panel judges, I'm not quite sure if it was brought before, when it was appeal, appeal, it was brought before 2 or more judges. So on what criteria did they basically...
Okay, thank you. The case from the mid or early 90s was called Eaton versus Brant County Board of Education. Emily Eaton was a little child who had significant disabilities. She wanted, and her family wanted her to be able to go to school in the mainstream school system, and wanted a choice for that. And the school board, if memory serves, said no. There was an internal appeal, and she lost. And so an argument was taken up through the courts. And the Ontario Court of Appeal, in a decision written by Justice Arbour, later went on to the Supreme Court of Canada, and after that on to other things of a comparable impressive significance. The Court of Appeals said, basically drew on the American experience of racialized kids in schools, that's separate but equal, sending kids to segregated educational environments is presumptively discriminatory. And that if the government wants to justify it, at least in a case where the family doesn't want the child segregated, the government has the burden to prove that that is the appropriate place. And the province, which I would think is right, kids with disabilities should be presumed to be able to go to school with kids without disabilities. Segregating kids with disabilities can cause all sorts of problems for the kids with disabilities, and educates kids without disabilities to think that kids with disabilities belong in segregated environments, not part of the mainstream. And Canada has historically been years, perhaps decades, behind the United States. The U.S. guarantees in a law passed in the early 70s has guaranteed the right of all kids with disabilities to a free, appropriate public education in the least restrictive environment. Now, there may be some cases where segregation is needed, or there may be situations where the family prefers segregation, thinking it's more appropriate. But at least the school board shouldn't be forcing a kid with a disability to segregation without justifying it under Charter Section 1. The government appealed to the Supreme Court of Canada. There were other procedural points I won't burden you with, but the Supreme Court of Canada reversed and concluded essentially that because she had an individualized hearing on her placement, that was enough. I'm oversimplifying, but in substance, that's it. And there was a dramatic moment in the Supreme Court of Canada during oral argument. I watched it on TV. Yes, blind people watch TV. When counsel for Emily Eaton, now Mr. Justice Stephen Gouge, of our Court of Appeal, argued, I'm paraphrasing because I'm doing this from memory, it's been a while, but essentially argued that this is akin to the sort of separate but equal approach that was denounced in the U.S. Supreme Court. And a member of the court, I believe it was Justice Gontier, said, well, kids with disabilities are different than racialized kids because racialized kids are born with their race. Well, Emily Eaton was born with her cerebral palsy or whatever the disability was. So there was a real disconnect, unfortunately, in the outcome and in the case between the principles of equality that we need. Fortunately, the damage was in the education context, but was the progress of the subsequent Eldridge case, the sign language, and the hospitals case really got all the attention and is the important case that's had a long-term impact. The Eldridge one.
If you don't mind, just a follow-up and another brief question. The question, the thing is, earlier, Mr. Honorable former Chief Justice stated that at times honorable and learned judges do err, and sometimes their error is not addressed appropriately, and as we can see with the case with the disability suit that was brought or whatever it was. I'm just going to stop on that and ask Mr. Grace. I applaud you for bringing up the matter concerning our beloved brother that has passed on, Charles Roach, who has resiliently championed some cases and still champion, even though he's not here, an issue that was dear to his heart. I just wanted to ask you, Grace, are you, being that you are a faculty of York University, are you, is it in your position to somewhat bring forth some of these issues to your students?
The answer is yes. I do have really interesting conversations with my students about these issues. Some of them come in with a fairly developed understanding of these issues. Sometimes they come in with and a developed sense of what the experience of particular groups in the society is with regard to whether it's human rights or economic rights. And so we have animated conversations, and hopefully that unsettles their knowledge base.
I think there's two more questions, so if we're running out of time, so if you can keep them brief, I'll really, really appreciate it because we have to finish at 6.
Yes. Can you hear me? My name is Edgar Godoy. I'm with the Ontario Federation of Labor, and I'd like for Avi and Brother Galabusi to talk about the impact on labor of this migrant migration changes to bring migrant workers. We're talking about hundreds of thousands of them, and now it's even legal, I believe, to pay less, 50% less or something like that. Can you elaborate what is the impact? Because my understanding is precarious work, is insecure jobs.
It's an economic question. It's
So, my analysis of what's been happening over the last 5 years with the new government is that it is a continuation of a process that I previously suggested was the neoliberalization of the economy. The idea is to bring labor into competition and lower the wages of workers. And the more people you bring into the country that do not have the same set of rights as the people who are in the country who are going to compete for the same jobs, the more likely you are to undermine the ability of those workers to bargain effectively and collectively for good working conditions, better wages, and the more likely you are to expand that experience of precarious employment that I was talking about earlier on. And in many ways, that along with discrimination in employment is responsible for the weaknesses that I was talking about with regard to socioeconomic status of racialized groups and immigrants in this in this city and in the country. So a critical piece of that, this again, 70% of us get our livelihood from the labor market. 70% of us. I often hear people talking about how we need to have self-employment and develop entrepreneurial skills and all of that. That's wonderful. The overwhelming majority of us are going to make a living, not by self-employment, but by being employed by other people. So issues of access to the labor market, equitable access to the labor market, we used to talk about employment equity, are really, really critical to dealing with the experience that I'm talking about. And the ability of labor to support the organized labor, to support effective bargaining by employees in workplaces makes all the difference. That's the difference between the post-war period and the last 30 years. The critical difference between the post-war period and the last 30 years in terms of redistribution is that we do not have institutional mechanisms by which we distribute income equitably.
Okay. I'd like to thank the panel for the very interesting discussion and presentations. I have a small gift for each of the panel members, except for Avi.
Thank you very much. Thank you very much. It's chicken. It's over inside. Yeah, there's.
Now we have our next speaker, and Carol.
Sorry? Yes.
I guess I'm on.
One more quick microphone check. Is everybody hearing me okay? Good.
Quiet.
Sorry?
A bit quiet.
Oh, that's because I put it. All right, well, I'll just hold on to it and speak into it and see if that works a little better. How are we doing now?
Much better.
Okay. The final segment of our conference looks to the future, and Susan Eng will offer us her perspective. She is currently Vice President of CARP, which advocates for Canadians middle-aged or older. This year, she was named by the Hill Times, which is required reading on Parliament Hill, as one of the top 100 lobbyists in the nation's capital. But here in Toronto, she's probably best known as the former chair of the Metropolitan Police Services Board. On her watch, the civilian oversight body tackled such issues as police accountability, the use of force, and racism in the ranks. More recently, as co-chair of the Ontario Coalition of Chinese head taxpayers and families, Susan was instrumental in winning a parliamentary apology and redress for 62 years of state-sanctioned racism. Perhaps you could begin, Ms. Eng, by telling us about the Chinese head tax and exclusion, which appears to be linked to the guarantee of racial equality in the Charter. Can you explain that?
Thank you, Carol. Remember that when the federal government instituted a law that said that all immigrants of Chinese descent were obliged to pay a head tax, And then they still came, and then they instituted an Exclusion Act, so they couldn't come at all, despite being willing to pay some 2 years' salary in order to enter the country. Not prepared to acknowledge that that was legislated racism. We didn't have the Bill of Rights then. We didn't have a charter protection at that time. Subsequently, of course, we did bring in the Charter of Rights and Freedoms, but that didn't propel the government of the day to turn around and say, well, about that racism back there that we instituted, let's apologize for it and let's provide some redress. And they refused to do so for some 22 years. In fact, during that period of time, a lot of the head taxpayers and their families died, as you do, when time passes. And it wasn't until the election of 2005-06 that there was any direct action on getting redress for Chinese Canadians, Canadians of Chinese descent, for 62 years of legislated racism. Now, what was the role of the Charter in that period of time? Certainly it was extremely important midway through the process, and I see a lot of my friends here in the audience who were instrumental at that time. It wasn't my role at that time, but they brought a charter action against the then federal government to demand redress pursuant to the Charter of Rights and Freedoms and to get redress for government-sanctioned racism. Obviously, it fits under the head, but the courts ruled otherwise. The court actually said that there was no apology necessary, and they lost their action. The specifics and the legalities of that, others here can better describe. However, we failed. Now, that failure came in handy later, but it does answer your question of, is it enough just to have a law? Is it enough to just have a charter? Is it enough that the government itself was responsible for legislated racism? Well, the answer to all of the above is yes and no. That is, if you have a charter, it allows people to actually fight for their rights. If you don't have the charter, they have no head of action, no cause of action to bring to court, raise the issue, and so on. Let me explain why it became important later that the court actually ruled that no apology was legally required. It came to pass that in the 2005-06 election, that the then Liberal government, which was in minority, refused, even at that time, to give any kind of parliamentary apology. They said that if we were to give a parliamentary apology, why then we would take up responsibility and liability for whatever kind of redress and unlimited amounts of compensation or whatever. And so they said, therefore, we will make personal apologies because we feel your pain, but we will not give you a parliamentary apology. And it became a critical fact. It was very interesting because we could then dredge up that legal decision that says, by the way, if you give us an apology, you still will not be liable because the highest court already said so pursuant to a charter challenge, which we lost, right? And yet they were not convinced. And it took the now Prime Minister to, in the course of the election campaign, remember, to make the promise that there would be, in fact, a parliamentary apology, which was more important than a simple personal apology. Then Prime Minister Paul Martin said, oh yes, I feel terribly, I apologize as a Prime Minister. Well, that wasn't good enough because this was an act of government. And so it was important that it be a parliamentary apology. So in that way, both the charter challenge, the fact that there was a charter, gave us the opportunity to raise an issue that seemed to be intractable for 22 years and changes of government.
From the perspective of racialized communities, is Canada more equal than it was 30 years ago, and what role has the Charter played?
Well, I don't know for a fact whether it's better. It depends on who you ask. It has to depend on who you ask. Certainly our self-image is that we are an equal society and everybody can come here and not be abused. But if you ask all of the people who have been abused, I think they would have a different perspective. And to some extent, it's more difficult to argue for protecting your rights when there is a self-image that we are in fact already perfect. So I think that it does, it cuts both ways. And I believe that the cause of equality has always to be pursued on an ongoing basis. There will be different people who will be marginalized, who will have their rights abused over time. I don't know, I guess with some pride, I suppose, some kind of backhanded self-congratulations, where we often say, well, you know, I heard politicians way back when, back to Mr. McMurtry, you know, the Irish were the first to be discriminated against. Of course, you're hard-pressed to find any Irish people who feel discriminated against today. And then they said, well, then it was the turn of this group and that group and the following groups. And you know, there is going to be common cause among different communities now who in their history were used as slave indentured labor, as the Chinese railway workers were. And now today we have all those meat packers at XL Foods. Let's investigate what their position is and how helpless they feel under the current circumstances as we natter away about rules and regulations. So it's not the case that we've solved our problems. We seem to manage to continue to hurt others as we go along. The only hope is that redress comes more quickly.
That certainly is the only hope for the mostly foreign temporary workers in that plant in Brooks, Alberta. Most of them will be long gone before a case could find its way through the courts. Do you think the Charter is as relevant in today's climate of cutbacks and wariness of court judgments that challenge government policies?
Oh, absolutely. And I'm glad to see that Chief McMurtry was here as well. And there's a bit of a contrast here as we're celebrating 25 years of the legal clinic. And also I see people from ACE here as well, the specialized legal clinics, which were created as a primary purpose to equal the playing field, right? To level the playing field so that people of no means could actually press their rights. Right? And so when we see the removal of the Charter Challenge Fund, it is actually bittersweet that we're celebrating the Charter while removing the tools by which we can actually pursue our rights under the Charter, but at least celebrate the persistence of the legal clinic system in Ontario that allows some measure of leveling the playing field. So I think somebody else mentioned that there is the law and then there is the implementation. The law is great. The law is perfect. But implementing it, as David was earlier saying, requires proactive work. It doesn't enforce itself, right? And silly though it may seem, we are obliged to ask the government of the day to actively enforce its own legislation, which sounds to me a bit idiotic, but there you are. That's where we are. And so that's why I think it's important that today clinics become an important measure of how well we can actually guarantee our own rights.
Looking at the role of the clinics and the increasing activism within equality-seeking groups, would you predict things are likely to get better or more discouraging?
As an advocate, I have to say they're going to get better. And it's our job as a collective to ensure that that is true. I think that it is true we make our own futures, and I see that the title of my session, you had the past, the present, and the future, and I'm not sure why since I'm talking about the past, but it may be the future in all our lives, and that is aging, because now I work for an organization that focuses on the public policy issues that affect our quality of life as we age. And unlike race, aging is a condition we will all share. It's a little known medical fact, but I've discovered it. And it does mean that we can find common cause across the different sectors who have been equity seeking to recognize that as we face the challenges of differential treatment by a healthcare system, by a financial system, our media, our rights, that the ism that we're dealing with, ageism, is almost identical to sexism or racism. You know, and so the same requirements to address them first of all, acknowledgement of what the problem is, finding that it touches everybody's lives, to identify both the legal rights that exist, and luckily we have codes of conduct and the charter and the laws that do exist, but extremely importantly, the obligation of all of us as advocates to actually pursue the enforcement of those rights.
You mentioned in passing that the Court Challenges program was canceled in 2006. This gave federal funding to groups that wanted to take charter challenges to the court and had no possibility of affording to do that.
Correct.
With that gone, should equality-seeking groups abandon charter litigation, or is there still some value in trying to exercise those legal rights?
You know, the reality of pressing a charter challenge in the Supreme Court ultimately is that it costs money. And while there are many lawyers who are prepared to take it on pro bono, it's a great burden on those lawyers who, of course, take time, and the jurisprudence is not readily available like it is perhaps in a, I don't know, Landlord and Tenant Act. This is something that requires original research, and they dedicate an awful lot of billable hours. I know many of you are thinking about your docket sheets, in order to provide the legal expertise necessary to bring it to court. In addition to that, even covering the disbursements, you know, photocopies, travel, witness expenses, is beyond the measure of a lot of people who are seeking to pursue their rights. So that was the purpose of the Charter Challenge Fund, to pay for that kind of thing. And the amount that even the lawyers could get for that kind of work was very minimal. It was less than legal aid rates. And yet that was taken away. So it seems to me that as a group, we first of all have to lobby for the replacement of that fund, and secondly, find other sources of that funding. So the fact that the clinic, for example, took it on as part of its own mandate to take on the Charter Challenge for the head tax, that is a tribute to both the dedication of the people at the clinic as well as the latitude afforded by the provincial legal aid system to allow that to take place. Right? But still, there were lawyers who were paid out of the Charter Challenge Fund. So it is, I think that it is something that the broader public needs to be aware of, that first of all, that these issues touch their lives, and that they should support allocation of public funds to level the playing field.
And the last question, looking ahead, what strategies should marginalized groups seeking to transform our society into one that truly embraces justice and equality have the best chance of success? And it can be in the courts, outside the courts, anything you wish to.
Well, we are lawyers here, so we have to use the legal system. But I will tell you about one other avenue that's exceedingly important, and that is the using of the political system, voting. Right? Racialized communities tend not to vote. Lower income communities tend not to vote. Right? Anybody who feels marginalized feels that, well, you know, why bother? Well, if you don't, then the politicians are not going to bother with you. Full stop. One of my great advantages at working at CARP is that I happen to be dealing with the very demographic that always votes. It just happens to be the case. Right? And we get constant calls from people saying, oh, this has happened to me, and I'm sure it was because of my age. Right? And we look at that, and you know, we can see that probably that could be the case. But so what we do is take their complaint, turn it into a policy recommendation, which we push with the government of the day and the opposition, and say to them, and we will tell all of our members what you do in response to what we've asked you. And what is more, we're going to suggest to them there's a direct tie between their voting intentions and what you do. Now, can we absolutely guarantee that connection? No, but we can certainly make the threat. And you, as an organization, as representatives of different organizations who try to get change in public policy, The reality is that if you can't spend money, spend the vote. Get organized, get out and vote, get out the vote, make it clear what you're demanding, and follow up by voting appropriately.
Do we have time for questions, Marie, or shall I wrap it up? All right. Thank you very much. You've been a great audience. I hope you learned a lot, and there is, of course, a reception afterward.
Thank you very much, Carol and Susan. We have gifts for you. So the celebration continues upstairs. Please join us for some food and drinks. And a reminder again, raffle tickets are on sale outside, and it's for a good cause. We'd like to thank our sponsors. Many people are responsible for making this event happen, law firms, individuals, but I'd like to thank the Law Society especially for making this event possible. Thank you. Oh, and where's David's AODA email list that was going around? Can someone just raise their hands if they know where it ended up? It's outside? Okay, thank you very much, everyone. See you upstairs.